Hi, this is Michael DelSignore. I'm a Massachusetts criminal defense attorney, and in today's video, I want to talk about some reforms that I think could happen in society and could be brought out by court action as a result of the George Floyd tragedy. One of the things that fuels racial tensions in America is that Black Americans are more likely to be stopped by the police, and pretextual stops are not really adequately covered by our Constitution. We don't have adequate court decisions interpreting the Constitution to really give meaning to this and to prevent pretextual traffic stops. So in 1996, a gentleman brought a case alleging that the stop was pretextual before the U.S. Supreme Court. It was Wren versus the United States. And in that case, the court said that we're not going to get into the subjective motivations of police officers in making traffic stops. In that case, essentially said, we're not, race or pretextual stops. The reason for the stop is sort of besides the point if you can point to a neutral or supposedly neutral traffic infraction. But as our traffic laws evolved, and there's so many of them now, there's hands-free laws, there's all sorts of laws about cars, inspection stickers, and these laws are frequently violated. So it gives police sort of the ability to essentially pull anyone over that they want to, because you can always find some minor, minuscule traffic violation to justify a stop. And that's what's happening in the United States. That's what's happening to many Black Americans. And we have a case before the Massachusetts Supreme Court that's going to hopefully address this. So it's called Commonwealth versus Long. And in this case, the defendant presented a very compelling statistical proof that he was stopped based on race. He was stopped in the population. Over 82% of the stops were Black Americans being stopped, and their percentage in the population was only 40%. He hired a statistical expert. They did a terrific job showing to the court that this was a racial disparity in stops based on the evidence. They got even better information. So motion to suppress hearing, you call witnesses and you have them testify, and the officer has to essentially justify why they made the stop. So the issue of motion to suppress is when you're alleging a constitutional violation, it's who's got the burden of proof. So the case is Commonwealth versus Law, and that established that once a defendant creates a prima facie case, then the government's got to justify it. So they presented that. The argument was they met what they called stage one because they showed that the statistics were compelling. They had other evidence. At the motion hearing, the officer basically agreed. They were with the gang unit. They said, we're pulling people over, but we've pulled maybe 1,000 people over and we've written 6 tickets. We're not really concerned with the traffic violation. We're looking for other stuff. So through the officer's testimony, it showed that the reason for the stop wasn't to write a traffic citation. The judge in the case ultimately denied the motion, but the Massachusetts Supreme Court took review prior to the case even being litigated. So the case is actually a gun case. They ultimately found a gun, and that's why the case is before the court. Let's say the gentleman had nothing in the car, then likely, unless he filed a civil claim, which are difficult to do based on doctrines of qualified immunity, which hopefully will also change in light of the George Floyd case, nothing would have come of it unless maybe he, in the extraordinary circumstance, maybe the person would have went to the police or the media. But there's a lot of incidents that happen that, Black Americans shake off and they go about their day. They go to work. They have other priorities, and these incidences don't come to light unless the person there is some criminal conduct that results in the case being brought to the court. So what the court's got to decide is what the standard is and there are some different ways the court could do this. I think the best way to do it, and the way that it'll have the most impact and prevent finances from preventing someone to make this showing, is if the court adopts like sort of a would-have test. Would the officer have made the stop but for race? So the judge would hear the testimony. The judge would have to judge those subjective motivations. It likely what would happen is the government would present the officer's statistical documents showing all of his stops and the reasons and different citations and say, yeah, this officer was level-handed, gave tickets to everyone for those violations. He just gave just as many tickets to white individuals as black individuals. And one of the reforms that I think will certainly come, regardless of which way the court goes, is they're going to require officers to keep statistical data. So ironically, as part of the, and sometimes when the legislature passes bills, there's different parts of the bills, things that get stuck in a bill. So part of the hands-free bill sort of made this information, sort of hid a lot of the information about stops from the public for some reason. That certainly has got to change. I think transparency is key part of reform. We need to know who's being stopped, why they're being stopped, for what reason. We need all the data out there. Officers should have cruiser video, cruiser cam, and there should never be an officer who, when somebody in the passenger seat wants to film somebody, is saying that can't be done. So those things, if we have the court interpret the Constitution, and hopefully our Massachusetts Supreme Court will take this opportunity to lead the way, to interpret the Equal Protection Clause the way it is meant to be interpreted, and find that if there's a stop based on race, a pretextual stop, then all the evidence gets suppressed in a case. And that, I think, would go a long way towards preventing pretextual race-based stops, and it will go a long way to strengthen the community ties between the police, black individuals, and all individuals based on race. Because there was a case out of Florida, which I think it didn't maybe get as much, it's been out of the media attention for a while, but it was the Randolph Moody money case. I might have got that wrong. So it was the Randolph Moody case, and it was from Florida. And what happened was the individual was stopped, and it was based on a tint in the window. So the windows apparently were violated the tint law. The officer pulls him over, shows him the measurement, shows him that the measurement that you had too much tint on your window. He keeps him there for 7 minutes. About 3 or 4 minutes into it, then he asks for his license and registration. He lets him go online. He shows that all the documents are in order. Then, at the 7-minute mark, he says, I think I smell some pot. Faint odor. Do you have any in the car? Now, then the defendant gets nervous. He says, what do you mean? What do you mean? They tell him to shut off the car. He doesn't. A few seconds go by. The officer then draws his gun. And then he takes off, drags the officer, and is charged with some serious felony offenses now. That case, I think people can have, when you watch the video, I watched the video recently and on that, people can have different views on that. That's a case where it did appear that the defendant in the case possibly had been smoking marijuana. Now, should it have gone to that part? If you believe the officer, you heard that there was a smell. And I think there's some indication that maybe something was wrong with his ability to drive. But it should have never got to that point. The stop, if the court can review stops and say, well, you can't just pull somebody over based on a hunch, tinted windows. How does the officer even know that the tint, just by seeing it, is exceeding the limit? Then the length of the encounter. If he was really concerned with the tint, he should have basically told them, okay, get it fixed, give him the ticket, and let him go on his way. There really was no need for further inquiry to hold him there, to keep inquiring. And if he really was concerned about the marijuana in that case, he likely would have mentioned it right away. So that's a case that had that, both the officer is okay, the defendant's alive. That's a case that, if we didn't have the pretextual stop, probably should have never happened if the officer was judging things without considerations of race. And I think why we need to get this right is because it's really going to divide the country. Now, this case with George Floyd, this was a clear case based on the video, what we've seen. And as a criminal defense lawyer, we're always taught to be cautious and not judge things too soon. But it'd be hard. What I've seen so far, I don't see any reason for the officer's actions. I don't think there's any dispute about it. It's been condemned. And what we've seen in terms of the reaction and the riots in different cities is scary, frankly, given that the officers were fired, that no one believes the officer was in the right. We had a rogue police officer. We're going to have, unfortunately, there are going to be police officers that are bad cops, just as you're going to have bad people in any profession. There are bad lawyers, there are bad doctors, there are bad accountants. But when you have a bad police officer, the impact of them doing something in their job can really be so much more in society. So we need better training, but we need to get this right because there are going to be a lot of cases where there are gray areas. And if one of those cases is tragic for one reason or the other, it's really going to divide us as a country if there's some hint of criminal activity. But it looked like, and that's kind of how this case from Florida is. There was another case recently, it was about 3 days before the case, George Floyd case, and it was from Texas, where the gentleman was stopped for allegedly driving erratically. That wasn't on video, but then the part on video showed he might have rolled through a stop sign. He was at his house, he wouldn't get out of the car, and he was brought out at gunpoint. And his grandmother, 90-year-old grandmother, came and sort of brought peace to the situation. So no one was injured in that case. But those are the types of cases that are really going to divide us as a country. So the court should, and I don't think it's a stretch for the Constitution to say that if officers aren't stopping based on race-neutral reasons, that should be a constitutional violation. So, and we have these tests in other areas of the law. So, for example, in jury selection, you can exclude somebody for whatever reason you want, but under the Babson case, you can't exclude somebody from a jury based on race. And in that case, we asked the judge to decide, did the prosecutor use a race-neutral reason? In employment discrimination, there's always this issue of motive. Was the person fired based on race or something else? So traffic stops should be no different. We should have a standard that looks into the subjective intent of the officer. It can certainly be rebutted. I think people are afraid that this rule will go too far, but if there's evidence of a 911 call, so someone else called, then the government likely would be able to rebut it. If there was evidence of, if they're investigating a crime specifically with regard to that person, then that's not something. But if you have an officer observing traffic infraction and it's a minor offense, it's not an offense where the safety of the public is subjective, there's no reason why we can't have a standard that asks what the intent of the officers. And what's the practical matter of that going to be? Practical matter is the police then will get cruiser cameras because they're not going to want to have their offices subject to this type of scrutiny. So that would greatly reduce the type of these challenges. It will basically just be down to inspection stickers and those type of violations. But the 10 miles over the speed, the claims of speeding, the marked lane violations, then you will be able to see the significance of it. And that's going to promote, and then we still would go into the reasons for the officers. But if the speeding is excessive, clearly then the race neutral reason is going to be stronger. Now, it's a very subjective standard. That's why we need our courts to enforce and interpret the 14th Amendment and the Equal Protection Clause to give meaning to them. And our Massachusetts Supreme Court is going to undertake that endeavor in the case of Commonwealth versus Long. So we'll await the decision. Hopefully we'll have that decision will help lead to meaningful change. So that's all for this topic. And if anyone has any questions, feel free to reach out to me. My name's Michael DelSignore. You can find me on Facebook, Twitter, any of the social medias. I'd be happy to talk to anybody about any of these issues surrounding race in society or criminal defense.